Hello, everyone. Many thanks for joining us today for yet another exciting event of the Center of Constitutions in Context at Warwick Law School, and welcome. My name is Mara Malagodi. I'm a reader at Warwick Law School and one of the co-directors of the Center for Constitutions in Context. I'm joined by my colleague and co-director David Vitale, as well as, of course, our esteemed speakers for today's event. Our event today is a roundtable discussion on artificial intelligence and constitutional law. I'll now hand over to David to introduce our panel of speakers.
Hi, everyone. Thanks very much for joining us. We had a bit of technological issues, and so we're trying to sort it out. But anyway, so as Mara mentioned, I'm David Vitale. I'm an associate professor at Warwick Law School, and I'll be moderating today's discussion. And I'm really looking forward to today's discussion, which focuses on what I consider to be a really timely, and I think, given the inevitable direction of kind of the direction in which our field is going, relevant to kind of everyone working in the area of constitutional law. And that is the relationship between artificial intelligence, or AI, and constitutional law, focusing particularly on AI's relevance and implications for constitutional law. And so to that end, what we've done today is we've assembled an exceptional panel of speakers, all of whom are working in this area. And so I'll start the discussion by introducing today's panel, whom I'm sure will be well known to you, and so I don't require much introduction. Unfortunately, only some of our speakers were able to sign on today because of technological issues. We're hoping that some of the others will be able to join, but this is the nature of, I guess, the technological era that we live in. So in terms of kind of the panels that the speakers that we have here today, so we're delighted to be welcomed first by Giovanni De Gregorio. Giovanni is the PLMJ Chair in Law and Technology at Católica Global School of Law and Católica Lisbon School of Law. His research lies at the intersection of European law and constitutional law, with a particular focus on digital technologies and policy. Giovanni is the author of a recent monograph in this area titled Digital Constitutionalism in Europe, Reframing Rights and Powers in the Algorithmic Society, which was published by Cambridge University Press in 2022. And additionally, he is co-editor of a forthcoming edited volume, the Oxford Handbook on Digital Constitutionalism. Next, we have Mila Versteeg. Mila is the Martha Lubin Karsh and Bruce A. Karsh Bicentennial Professor of Law at the University of Virginia School of Law. Mila's research focuses on comparative constitutional law, international law, and empirical legal studies, with her work having been published in award-winning books and articles in both legal and social science disciplines. And of note for today's discussion, Mila has recently completed work and published on what AI knows about comparative constitutional law. And then last, but certainly not least, we have Richard Albert. Richard is the Heinz H. Baker and Thelma Kelly Baker Chair and Professor of Law at the University of Texas at Austin School of Law. Richard has published an impressive list of both books and articles on various aspects of comparative constitutional law. And recently, his work has explored the implications of using AI specifically for constitutional drafting. So welcome all. We're really, Mara and I are thrilled to have you with us. And so with those kind of brief introductions, just a few quick points about how the roundtable discussion will run. So the principal discussion will run for approximately 75 minutes. And that discussion will center on some predetermined questions that we've set to ultimately guide the discussion. And then after that, we hope to have a few minutes at the end for audience questions. So if you would like to ask a question, please pop them into the Q&A section of Teams, and Mara and I will do our best to collect them and convey as many as time ultimately permits. Okay, so with all that said, let's get things going. So I'll start with kind of a general question. Oh, it looks like Jen was able to join.
And so has Aziz. So full team.
Well done. Hi, Jennifer. Good to have you with us. Let me just also introduce them. We've managed to get Jennifer Raso to sign on. And it looks like Aziz has also managed to sign in, I hope. So just with that, just hopefully Aziz will be able to kind of sign in. But so our additional panelists, we have, so Jennifer Raso has successfully managed to join, which we're absolutely thrilled. So Jennifer is assistant professor at McGill University Faculty of Law. Her research investigates the relationship between discretion, data-driven technologies, and administrative law. And she's currently the principal investigator on a project funded by the Canadian Social Sciences and Humanities Research Council titled Shifting Front Lines in the Digital Welfare State, Coding Canadian Social Assistance Law. And assuming we managed to get Aziz successfully onto the screen, Aziz Huq is the Frank and Bernice J. Greenberg Professor of Law at the University of Chicago School of Law. Aziz's scholarship, which has been published in, again, an impressive list of award-winning books, as well as articles in leading journals across disciplines, concerns diverse aspects of both U.S. and comparative constitutional law. And most recently, he's been working on democratic backsliding and the regulation of AI. And he's published on, among other issues, the geopolitics of digital regulation, constitutional rights in the machine learning state, and the advisability of a quote-unquote right to a human decision. Okay, so let's then go to the substance of the discussion. So I guess to kick things off, I guess I'll put it to the panel as a whole, because I'm not sure whether or not Aziz is able to kind of participate, or at least kind of vocally and visually. So I'll put the panel to kind of everyone, and feel free to kind of raise your hand just to kind of kick things off. But I guess to make sure that we're all on the same page, when we're talking about kind of artificial intelligence and kind of its implications for its relationship to constitutional law, what exactly do we mean by artificial intelligence? Does anybody want to kind of take that question just to kind of get the ball rolling?
I could jump in here, David, if you can hear me.
Yeah, we hear you great.
Excellent. Okay, so I'm fully here. Yes, I mean, so this is, I think, a question that I get asked quite regularly, and it's one that you know, I think there's a few different approaches in terms of how we answer it. So you might ask, what is AI for governments that seek to use artificial intelligence? And very often the term AI is a stand-in for a lot of different things that may not actually, if you ask, a computer scientist, they may not actually count as artificial intelligence in the eye of a technologist. So, AI, from what I've seen in Canada and in other jurisdictions, is often a kind of catch-all phrase that's used to include things like risk assessments, data-driven decision-making or data matching initiatives, other types of tools that are kind of quantitative in nature, and then is increasingly also encompassing things like image recognition or facial recognition types of technologies, and even text generating technologies as well, or technologies that summarize text and present it to decision makers as well. I've seen all of these different examples in Canada. So there's kind of an ebbing and flowing of what is and isn't AI when you ask government officials, or when you see AI being used as a phrase for capturing what it is that governments are doing these days. But of course, if you want to get very technical in a discussion of AI, then we might think about, the older terminology that was used. And by older here, I mean maybe like 5 or 6 years ago, thinking about machine learning systems that learn on their own with or without human supervision, and so on and so forth. And so I think that this is one of course, the challenges of working in this area is that we're not always all talking about the same type of thing. And so being clear about the definitions, both as scholars, but also when we're engaging with wider publics and even folks within government is really crucial.
No, thanks for that. Yeah, I guess with like most things with law, kind of, these terms are, loaded, and ultimately we can kind of, try to figure out, and the way in which we define them ultimately depends on, or ultimately determines kind of the implications and the broader discussion around kind of its relationship. But thanks for that kind of, at least kind of foundation that we can then kind of use as a platform for kind of discussing the topic more broadly. So I guess, staying with you, Jen, I guess, one of the things I think that's assumed when, we talk about kind of, or when we're discussing current debates regarding AI and constitutional law, or perhaps public law more broadly, as your work in administrative law, one of the things that's assumed is that AI is either currently being used very widely by governments globally, or that it could soon be used by governments very widely, I guess. So I guess to just to kind of, for a certain sort of reality check, I guess, in your experience, is that assumption correct? Is it something that's, being widely used, or is it something that's kind of, relatively rare?
Yeah, so I think on this question too, it depends what the AI is that we're talking about. So government agencies have a long history of using the kind of wider catch-all types of tools. So if you think about risk assessment tools, so those are tools that would be used to take in different types of data or information about a person, consider that data in light of different statistical analyses of that type of data, and then produce some sort of a score or ranking of that person in relationship to others in terms of, whether they're at risk of, committing violence, or if they're a child, whether the child is at risk of neglect or abuse, so on and so forth. Those types of tools have quite a long history of use in a variety of administrative settings. So you can think about prisons, child welfare agencies, and increasingly in Canada, I've seen these tools being used in social assistance agencies as well. And so those sometimes are included when governments are talking about AI, and sometimes they're not. But those have, a few decades of history of use in Canada and other jurisdictions. There's other tools too, like data matching tools, that also have a longer history, but perhaps, the pace at which the data matching results would be produced was a lot slower. So we might not have thought of them as being, having the same effects that they have today. So for example, matching records of an individual who's on social assistance with their records in a tax authority, and then perhaps even records that might exist about them if they've had contact with a prison or a jail. That would have been done previously, but it would take a lot of time to match everything up. And today, the key transformation there is that there's increasing interoperation between database systems, so that the data matching can be done more quickly and consequences can flow more quickly when the data is matched up. So there we have a history we can draw on, and then perhaps new changes in terms of the pace of the effects of that data matching today. But then when we're thinking about other types of tools, like the things that, if you were to read the news, might be described as AI, there's other tools like facial recognition technology that is increasingly being used in border security, decision-making, and immigration as well as even generative AI tools that are being used to either summarize documents and or produce first drafts of decisions in some cases. And I know these are being used in different settings in Canada, and of course elsewhere as well. And I would say the key question that comes to mind for me when I'm looking at this landscape of kind of old and new technologies and technological evolution is, the degree to which there's transparency at all about what's being used where and with what effects. And I think that that's a real problem in Canada and elsewhere. What we know and what we don't know about what's used really shifts, and there's often times, surprises that come up in day-to-day interactions. For example, this morning, I was just provided some letters from an immigration lawyer that suggest that generative AI is being used by federal immigration authorities in Canada to do, processing work. And this was included at the bottom of the letter in text that just said that the agency used generative AI to support the processing of this person's application, and all generated content was verified by the officer of record. And that's it. There's no other information about what does this mean? What kinds of processing are we talking about? Where's the line between processing and decision making? And for me, as somebody who's concerned about, administrative law implications, including discretion, reliability, even the degree to which somebody can appeal or have the results judicially reviewed, there's a lot of kind of opacity about the use of these tools. Which tools are we talking about? With what effects, and so on. And this is a real challenge, I think, in terms of what I've been seeing in Canada and elsewhere.
Yeah, no, thanks for that. Yeah, it's really interesting. And I think we'll obviously kind of get more to kind of the concerns around AI. But so in terms of talking about, let's say shall we say the implications of using AI in this area of public law, constitutional law. Let's start with some of the perhaps being a bit optimistic. Let's start with some of the positives. So the advantages of kind of using AI. So here I'll start with, or I'll turn to Richard, if that's okay. So I guess Richard, based on your work, so as I mentioned before, kind of you've done some recent work on using AI for constitutional drafting or constitution making. So I guess starting with you, what do you see as kind of the benefits of using AI when it comes to drafting or making a constitution?
Thanks so much, David. Am I audible? Great, thank you. And congratulations once again to you and Mara on running this new and exciting center. It's really a gift to the study of public law, and can't think of two better leaders to lead it than the two of you. So congratulations. I've been giving some thought to how we might use AI in making and reforming constitutions. And I have to say, it's not just thinking, this is actually happening already. And I can speak from personal experience in this capacity. For the past 2 years, I've served on the Constitutional Reform Committee of Jamaica. It's a committee convened by the Prime Minister to advise on writing a new Republican constitution for the country. So the appointment was effective in March 2023, and now things are on pause in the aftermath of a recent election in September 2025. But in that time, in that 2.5-year period, seated around this table, 15 people, I'm the only non-Jamaican on this committee, people like the Attorney General, the President of the Senate, the Minister of Legal and Constitutional Affairs. It's a really interesting group. And just seated around the table, I can tell you that AI was used in the conversations. I can't disclose how, but I can tell you that it's being used. But to answer your question more specifically about how AI might help to benefit those who are involved in making and reforming constitutions, let me just address maybe some low-hanging fruit, things that are easy to do using AI, and things that AI can do well, things that will only get better when done by AI in the days and weeks and months ahead. So for example, St. Lucia in the late 2000s or early 2010s went to court because there was a typo discovered in its constitution, a typo that actually had some serious ramifications for the future of the country and whether it could accede to the appellate jurisdiction of the Caribbean Court of Justice. But a typo that could have been fixed easily. Everyone understood it was a typo. No one contested it. But the problem was that to fix the typo by amendment, the country needed to go to a referendum. And referendums are notoriously difficult to win in that part of the world. And so instead of going through the formal legal route to correct this error, something we knew was an error, everyone knew was an error, St. Lucia chose to go to a court, to ask the court to read that typo out of the Constitution. But that could have been avoided with AI. A second easy, low-hanging fruit use of AI when it comes to constitution making and constitutional reform brings me back to an experience I had in Albania in 2015, 2016. I was asked to undertake a conformity review of Albania's draft constitution with a view to its future accession to the EU. And so what this entailed was reading their draft, significant draft of a reformed, heavily reformed constitution, and then seeing whether or not it conformed to the expectations that the Venice Commission had for members of the EU, entailed comparing this draft constitutional text to other EU constitutions, and it entailed a conformity review to EU treaties and the expectations generally for member states. I did all that on my own, text by text, but that could have been very easily accelerated with the use of AI, simply uploading all of the relevant documents, asking AI to take a first pass through it. And then, of course, all of this has to be reviewed by an expert, someone who knows what's going on. But AI can really give that person or persons a head start. So drafting errors, conformity review is a second thing that AI can be used to do and do well. A third brings us to a recent, really high-profile set of dramatic failures in constitution making in Chile. Chile was engaged in two really important efforts to write a new constitution from the years 2019 to 2023, 2024. Two failed referendums led to the end right now, for now, of the process. But in those two processes, there were over 300,000 public submissions from the people about the various drafts, proposals, suggestions, recommendations for these two new constitutions. So how can AI be useful dealing with these 300,000 submissions? Well, AI can help to aggregate them, to synthesize them. AI can do some thematic processing. And then AI can very easily acknowledge receipt with a personalized, tailored response to those who submit something by email, for example. And of course, AI can also help to archive systematically and thematically all of these submissions for historical purposes, very important for posterity. So 300,000 participants is a big number, but not as big as South Africa's 2 million in its own drafting experience in 1994 to 1996. So these are just 3 or 4 different things that AI can today do very well. And all of these are low-hanging fruit things. And I think none of these raises the concerns that people typically raise when it comes to blending machines and humans in the most important thing that there can be when it comes to self-governance, and that's writing a constitution. This is not AI writing a constitution, for example. By the way, that's not out of the realm of possibility. Last September or October, the current president of Ecuador said, ChatGPT will write our new constitution. And as you can imagine, that raised a lot of interest from people, not just in Ecuador, but in the region and the world. I'm not suggesting that be done. But perhaps one day AI can be used in a way that's responsible to take a first pass at some parts of a constitution, and maybe all of the constitution. That's not something I'm comfortable with right now, but some people are around the world, including people who will write and promulgate constitutions, like the current president of Ecuador, who proposed at the time convening a constituent assembly to write a new constitution. He lost that battle, but he might try again this year or next. So, David, thanks for that question. Those are just some low-hanging fruit things that AI can be used productively, easily to do, and I think without arousing really high levels of discomfort about what AI's role is when it comes to self-governance. There are other things we can talk about that I do think push the envelope in ways that might make people uncomfortable when it comes to using AI in constitution making, and I'm one of those people. For example, and here I'll close, David. For example, using AI to help update the amendment rule of a constitution in midstream. So the constitution is enacted at time one, given a particular configuration of political parties. And then at time two, there's some kind of a change in that configuration of power leading to a paralysis, an inability to use the amendment procedure because time and circumstance has just made it impossible to use that amendment procedure given how divided the parties are now, and they weren't at time one. So you can imagine using AI to change the thresholds needed to reform the Constitution in midstream in light of this dramatic shift in the configuration of political power. I'm not ready to recommend that, but I'm interested in learning more about that, just to learn about it. So, David, thanks for that question. I think this is an exciting time for people who are involved in advising on constitution making and also writing constitutions.
Yeah, thanks, Richard. That's no, it's very interesting, and I think with the benefit of kind of the concrete examples that you've provided, it really kind of puts it into context. So that's great. So Mila, if I can bring you in here. So obviously your work kind of has, in your recent article, for example, you've looked at kind of the use of AI in, I guess, broadly speaking, what we can call kind of comparative constitutional law research. And I'm just wondering, kind of, it includes, I guess, to some extent, kind of constitution making or constitution drafting, but I guess more broader than that. So I guess, what kind of, beyond perhaps the benefits that kind of Richard has flagged for us, are there additional or other benefits that you can see for AI in this area of comparative constitutional law research?
Wonderful. Thank you so much for bringing me into this conversation, for hosting this very timely panel. I obviously have thoughts on this question, and I think overall, I think there's some things that AI is good at and some things it isn't. But let me phrase some of the things that it's good at, and that's sort of low-hanging fruit, to use Richard's term, on comparative constitutional law research, right? So obviously, comparative constitutional law research is necessarily resource intensive. It requires consulting legal documents in different countries, in different languages. We have lots of different countries and languages. We actually speak only relatively few of those, right? So, and one of the problems in the field has long been that some countries are far more studied than others, right? So and I think, and no human researcher can read everything in all these languages about all these countries, including historical constitutions, historical court decisions, even conventions, right? So I have found that AI's language, sort of knowledge on different constitutional systems, at least superficially, is pretty strong, right? Like if you want to be like read up on the constitutional history of, let's say, the Zambia, right? Like it can get you a pretty decent first cut at it. Now I have to say, like, don't ask it for sources. It's really quite terrible at that, right? Like, because it will make them up. And it's funny, as somebody who's been in the field for a while, like I sometimes see like it spits out my own name as to support the proposition I'm looking for. And I was like, I certainly didn't write this article. So it's, anyways, but the factual knowledge is often not wrong, right? And of course, it's only sort of once it gets into deeper legal questions, it becomes more difficult. But a first cut at studying a particular country, I think it's actually helpful, especially for the jurisdictions that we haven't studied, that are relatively understudied in the field. Second, and I think here it's a little bit related to what Richard was saying, I think it can certainly accelerate the more mechanical research tasks that involve the analysis of large bodies of text. So to give you an example, I wrote my dissertation in, when did I graduate? 2011. And as part of my dissertation project, I coded every historical constitution that had ever been written. So I sat in the Oxford Bodleian Law Library for 8 months and just read all these documents and put all this in my Excel spreadsheet. And it was super interesting because, but also kind of boring because you're just reading constitution after constitution. And there's now papers that show that this kind of work could easily be done by AI. If you feed it a body of text, it can analyze and code that pretty well, right? Like there's even been a paper that's like, oh, Versteeg's data set could easily be coded by AI in 10 minutes, right? Which I guess, it's a good thing I did it some while ago, but that's certainly something it's very good at. Actually, the submissions in the Chilean process, I think the team in Texas has analyzed those using AI and sort of come and to figure out what are the different topics that came up in those submissions, right? So I think having it analyze large bodies of text, it's pretty good at it if you feed it a corpus, right? So that's certainly the case. Third, in the research that I've done on JetGTP's knowledge of comparative constitutional law, this is a project with Adam Chilton, Jan Ulrich Dittmer, and Arthur Langlois. And what we basically did was a benchmarking project. So we tried to give it data that we knew was right, or at least we thought is right, but had been coded and created by humans. And then we asked JetGTP to recreate these data sets, whereby we sort of treated the human coding as the ground truth, like this is what it actually is. And then we asked JetGTP to do the same thing. And it actually did pretty well at simple fact-based data sets. So for example, the question whether there was a referendum in ratifying the Constitution, it got like 97% of the time right? It actually can find this kind of fact-based information, or whether a president stayed past the end of their term. So I think creating constitutional law related data sets can actually be done from scratch with AI, but only, and this is a really important caveat and I'll elaborate on more later, only for certain type of data, right? But I think, this is obviously important. It is possible to do that with AI because we tested its performance in this area. Finally, this is not necessarily a fourth, but it is a point worth making. I think it's for the field as a whole, this has the potential to substantially democratize and make more accessible comparative constitutional law research, right? These data collection projects often require lots of funding, lots of research assistance, lots of time. And now with AI, you can create these data sets, analyze bodies of text, also in settings that are more resource poor, right? So I can see researchers in the global south outside of elite networks with less access to funding doing this work just as well as those who have more access to funding, because it allows you to do this without a large team of researchers, basically. So I think there's some potential, there's lots of promise there for the field in this respect. I think we can think of this as a structural benefit for the field of comparative constitutional law research.
Great, thanks. And I think both you and Richard have kind of flagged kind of the discussion we're going to have in a few moments about kind of some of the things that maybe AI is not so good at, but we'll kind of deal with that just in a few moments. Before kind of progressing or going on, I guess if I can bring Jennifer in now. So I guess for some perspective on kind of more broadly on administrative decision making. So and I recognize administrative decision making is quite a big area. But I guess what do you see as kind of some of the key or principal benefits of AI for kind of that kind of field of administrative decision making, perhaps kind of beyond what Richard and Mila have kind of pointed out?
Thanks for this question, David. Yes, and so administrative decision making is a hugely expansive field, as you've noted. So, I mean, some way that AI tools, especially if we're thinking about generative AI, might be useful for decision makers who are producing decisions that are accompanied by some sort of narrative kind of text explaining the decision and perhaps even justifying it to a member of the public. I could envision these tools being useful in helping to polish that text and perhaps make it more intelligible and flow better. And I've seen different agencies in Canada who, and even tribunal members who have expressed that desire to use AI tools in that way. So you could think of that as a kind of like end stage kind of refinement as an AI functionality, perhaps. And I think that there's definitely perhaps a benefit to that type of AI use. However, I think there's some challenges that come along with that, which could include the degree to which the aesthetic of kind of smoothness or reasonableness might be used as a veil to kind of cover what's happening behind the scenes. And this is also, of course, something that has been raised by administrative lawyers in Canada. And that isn't a new issue. It's one that we've seen raised with the use of other tools like templates for decision making, for example. But it's, I think, something that's a growing concern for folks who are working within administration and also, of course, for those on the outside. So that's one type of use that I could see AI tools being put towards with some benefit if it actually enhances intelligibility. Another way that AI, or if you want to think about it a bit more broadly, like digital government types of tools might be used with a benefit in administration would be at the level of more kind of like frontline decision making, where they might make access to administrative justice more tangible and more of a reality for more people. So, for example, in different programs where their access to the program is now granted through digital interfaces. For example, the United Kingdom's Universal Credit Program. I know there's been some moves to have the interfaces in those programs include appeal buttons or include easy pathways for appeal. And this is, of course, you might say this isn't AI related, but oftentimes this way of kind of architecting a system is thought of as AI when we're talking about digital government. And so I know there's been a push by organizations like the Child Poverty Action group in the UK to ensure that these types of easy to access appeal mechanisms are things that are built into the tools themselves, so that for members of the public or claimants, they can hit a button or undertake a relatively simple action to engage in an appeal. And another example that comes to mind that's rooted in the Canadian context would be improved data matching. So, for example, in the province of Ontario here, when individuals who receive social assistance benefits end up being incarcerated, so especially when they're brought to jail on charges that they haven't been convicted, but they're picked up by the police and brought to local jail, data about their entry into the carceral system is sent to the benefits program that they're receiving benefits from right now automatically through data matching, and their benefits are paused. But there's not a kind of correlated sharing or transmission of data when they're released from jail a few days later. And so what happens is that their benefits remain paused and then eventually can be terminated, sometimes without knowledge of the person who's impacted. And so I would imagine that an easy type of benefit that could happen would be corollary data matching that happens on exit, where you have a transfer of information again to the social assistance agency so that the benefits are restarted. So this, I think, would be, again, thinking about low-hanging fruit. This is really low-hanging fruit, and this is something that could be easily done. But for reasons that I'm sure are at top of mind to people who are here today, and the politics of, why certain types of AI projects are undertaken and others are not, this has not been a priority of the government that's used the data matching to cut the benefits off. So I would say that there's nothing stopping governments from ensuring that benefits, including benefits from efficiency gains from AI systems or algorithmic tools, are spread around more broadly. But I think that this is one of the challenges, of course, is that that's not necessarily top of mind for administrators or ministerial officials when they're introducing such tools, unfortunately.
Great. No, absolutely. And thanks for, obviously, like I mentioned, I was a big field of administrative decision making, so I guess it's hard to kind of capture it all. So I guess let's shift kind of gears to some of the, I think we've all kind of mentioned to some extent some of the downsides of the concerns around AI, but let's kind of focus on that a bit more now. So and for that, I'll turn to you, Giovanni, if that's okay. So I guess from your perspective, what do you see as kind of the greatest disadvantages or threats that AI poses for constitutional law?
Yeah, thank you so much, David. And let me join the group just to say thanks for organizing this conversation on AI. Also, thanks to you and Mara. To be fair, most of the focus usually is about, AI's implementation and use by, public administration and government, generally speaking, even in the area of security and defense and so forth. But one of the big questions when it comes to constitution is also about the important role also that private actors have in this picture, because the reliance on AI is not just about, something that concerns, I don't know, like the law enforcement using biometric technologies, to take on certain types of, conduct or whatever, but it's also about, what about is the role of, public administration and governments when it comes to the development of these technologies, even when it comes in conversation with the private sector? Because, we know very much that, most of, the development of new AI systems, the models and the systems that we are using every day, the applications we are using every day are not very much pushed by governments, but very much pushed, by private sector, and I say this is important for not only for constitutional law, but also for administrative law for many reasons, because this technology then are developing in the private sector with a certain type of, not only features, but also values transitioning, of course, to the public sector, and this is actually interesting because we have been seeing, as in the last, basically, I would say these days, 30 years, and even maybe, say 20 years, increasingly see this expansion of private governance when it comes to digital technologies, so much that, public actors have become like empty box, like regulators, just trying to wait for the private to, fill in the box and say what they have to do, and indeed, we have been seeing, especially if you think about from a perspective of the European Union also to bring there actually to the table, we've seen that this incredible expansion, of the regulatory side as an answer actually to this type of empty box that the regulators have become in the last 20 years, And this is not only because of, and this has also followed narratives of fundamental rights, narratives of the rule of law. And this is actually where you see constitutional values kicking, basically, turning back, to the picture, after, 20 years of trying to see, the value, coming out of the market when they can develop this type of technology. That was completely, fine and optimistic. That's okay. It's a little bit what we are observing nowadays with AI, the hype with AI is also related to the optimism that is out there about what AI can bring for society, but there are also challenges with that. But the challenges for constitutionalism are not very much related to the entanglement and, to public and private actors getting increasingly close when it comes actually to the development and the implementation of this technology in this race so many questions when it comes, like to transparency, the rule of law, the public-private divide, you name it, really. Like it's really one of the big challenges in constitutionalism, this relationship between the public and the private is increasingly entangled. First point. The second point is that this actually has been, like stressed by the scholarship, but this is actually something that has been discussed, especially when looking at the big techs, the online platforms and so forth. But there is even, and then I stop there, there is even another important layer that is not all about private governance, but it's also about technological governance. And I'm referring to something that Jennifer actually mentioned before. This is about automated decision making for one reason, but one very simple reason. Also, the more actually the public, even administration delegates, decision making to AI, but this happens even to the private sector, the more actually, generally speaking, the system and also public administration is exposed to a logic and also to a decision making that is totally unaccountable. And this is not just about for public administration, it's also for private actors, to be fair. Let's use the example of content moderation, and then I stop there. Whenever you have a social media platform doing content moderation using AI, like moderating whether a content should be shut down because it's hate speech, they have no idea whether it's hate speech, because it's the AI making that call at first glance. And then you look at terms of services and whatever, So this actually shows that at the end, there is also a normative power when it comes to AI, especially when we talk about machine learning and when we talk about AI systems. And this normative power is particularly concerning because it has a third layer of governance between public governance, private governance, and technological governance. So if you want to call it something that we try to name, and also other scholars try to name it as the rule of tech, is precisely the challenge for constitutionalists to develop accountability mechanism where you are not able to explain, but not to provide a motivation, but really to explain, what's going on. And this is horizontal, both to public actors and private actors. And so this is actually what should be quite concerning for us, like when we look at the big picture, what are the challenges of that AI brought to constitutionalism and constitutional law?
Okay, great. No, so I think the way I'm understanding it, but I could be wrong, but I think in terms of talking about kind of AI and constitutional law and the disadvantages of it, so I think there are the practical disadvantages in terms of, going back to the conversation around kind of, what AI is good at and what it's not good at. And then there's also kind of the concerns from a constitutional standpoint in terms of kind of the implications that it'll have for constitutional values for fundamental rights. So let's start with the first kind of part of things. And for this, I'll turn to Mila, if that's okay. So I guess, picking up on the conversation around what AI is good at and perhaps, let's say, not so good at, you've done a bit of a discussion around kind of what it's good at. What would you say it's not so good at, or what has your research shown that it's not so good at?
Right. So I am going to confine my answer to this much more narrow question, like using this as a tool for comparative research. Potentially, I mean, in the paper I wrote, we respond a little bit to Richard's provocative work where, if I'm not mistaken, they surveyed constitutional law scholars about whether they thought AI could be useful in constitution making. And then the overarching response was sort of no. But a substantial number of these experts thought it would be helpful with like constitutional law research, right? To do comparative constitutional law research to inform constituent assembly. Was it 80% or something like that, Richard, of your, it was high, right? So the idea is like, oh, constitution makers could rely on this tool and find out about the world. And I just gave you all a spiel of, what it can do and how it can be useful in taking a first cut at exploring certain issues. But with the research project that I mentioned before, this benchmarking project. And a benchmarking project exists in a lot of areas. So there's this project called Legal Bench, where it basically asks AI to complete all sorts of legal tasks and then compare it to a ground truth that was established by humans, and just to see how well does it do, how often does it get this wrong or right. So we did a benchmarking project for 4 well-known comparative constitutional law data sets. So, and we basically said, okay, we have the ground truth established by humans. How well does ChatGPT and Grok, we also looked at Grok 3, to do at recreating this knowledge, right? How do they reproduce this knowledge? How good a job do they do at this? And what do they get wrong? And if they get something wrong, are these errors systematic? And the answer is yes. So one data set we looked at is like captures different aspects of executive term limit evasion, so whether a president overstayed past the end of the term, but also what legal strategies they use to do so. There's a data set that I created together with Annie Meng and other collaborators. We looked at a data set on constitution-making processes at work by Gabriel Negretto and others, where they try to capture this concept of inclusive constitution making beyond just participation. So you have popular participation, but also whether there's something like consensus among different elites, right? It relates to Don Horowitz's work, concept of consensus. So they try to code that. They call it plural elite agreements, like different sides of the political spectrum need to be on board with a constitution making process. We looked at the Comparative Constitutions Project coding of first generation rights. But importantly, we did so without feeding it text, right? So it's actually pretty good at if you feed it a corpus, like a body of text, and then code it. But if you just ask, oh, how many countries have what we did instead is like, how many countries, tell us which countries have a prohibition of torture in the Constitution without first feeding it the text. So that's how we approach that data set. And then fourth, we asked them about what the nature of constitutional rights protection is and whether it was mainly in the small c constitution, like court decisions, conventions, organic laws, or whether they were mainly found in the large C constitution, which is a data set Adam Chilton and I created some while ago with the help of many comparative constitutional law experts from around the world. So we gave it those data sets and assets and asked it to recreate it. And I think the insight is like, it did pretty well on very straightforward, simple binary variables that I mentioned before. So whether the president overstayed, right? Like 5 + 5 is 10, and the president is in office in year 11. That's usually all over the news. It can figure that out. However, the legal strategy that the president used, not so much, right? But that's the simple fact-based finding. It could recreate pretty well. Like it was something like 96% right of the time compared to the ground truth. So that was, we think, pretty good. It also could capture whether there was a referendum for ratifying a constitution. Also, again, it's simple, doesn't require lots of conceptual judgment. It's binary. It's all over the news. It figured that out, did a pretty good job at it. But the performance was pretty bad when we were going to ask it about more sort of, complicated constitutional law concept. So asking it whether there was plural elite agreement, meaning all sides of the political spectrum were on board with this constitution, which requires more context-dependent judgment, which required more research, which is a more complicated concept. It did a pretty bad job at it. It was like a little bit better than random chance, but not much better than random chance. Asking it which rights are in constitution without feeding it a corpus, it was the accuracy was like 50%, which means it was basically guessing. Not very good job at asking it how many countries have freedom of information in their constitution and list those countries. It doesn't do a great job. Maybe if we train it, we didn't train it, but then we could have done better. But just asking it for this kind of information, which plausibly the constitution maker would ask for, it didn't do a great job at that. What is the nature of constitutional rights protection? Also not much better than chance compared to our experts who we had, constitutional law experts from those countries that we had asked to characterize the nature of constitutional rights protection in their country. Those errors, though, not only did it do a bad job, the errors were not random, and that's important, right? So one thing we found is that we found evidence of what is known in the literature and familiar to everybody of hallucination bias. So it was more likely to say that something occurred than that it did not occur. So even with the term limit evasion, it's more likely to say that, oh, they did overstay past the end of the term, even though it didn't happen. But for example, were citizens involved in the constitution making process, it's more likely to say yes than it is to say no. So it's and for the first generation rights, like most countries have a prohibition of torture, so it just guesses that all countries have a prohibition of torture. So it hallucinates whatever the largest category in the data is. So that's one source of bias. The other thing we found is very related, what we can call a majority class bias. So if we asked it for different strategies or like non-binary variables, so there was 3 different ways in which a president can overstay past the end of the term: amending the Constitution, replacing a Constitution and saying the clock starts over again, right? That's also a strategy. Or third, getting the court to interpret a term limit out of the Constitution, which has happened. Amendment is the most common strategy. So it just defaults to saying, oh, it must be amendment. So that was one thing we found. Also, maybe this is interesting. When we asked it, what is the nature of constitutional rights protection? It always says the text of the Constitution, even though many of the experts say, no, it's not the text of the Constitution, it's court decisions, or in our case, it's organic laws that interpret these. So you could say, oh, ChatGPT is a textualist, or even an originalist. It goes by the text, right? Not like all the ways it has been interpreted. But I mean, it was also just simple majority class bias, because in our data set, most experts did say it was the text of the Constitution, but not in Australia or in New Zealand or in, I don't know, Israel or the UK or the US, right? But it just defaults to that larger category. So I think it's not only do you get the wrong answer, you get the answer that is wrong in a systematic way. It's more likely to think that things happened than that they did not. And I think it's really important to be aware of those biases, not just that it's not very good at gathering this kind of information.
Thanks. Really fascinating, and it's interesting to kind of have like a systematic kind of approach where sometimes we kind of think we know what it's good at and not good at, but to kind of actually have it kind of in-depth studied in your study. That sounds, that's amazing. I guess opening it up more broadly, do others kind of want to come in terms of what picking up on that conversation around what AI is good at and not good at, I guess, perhaps beyond kind of comparative constitutional law research. So either perhaps Jen with administrative decision making, or anyone else in terms of, are there things that people want to kind of add in terms of what they've found that AI is particularly not good at?
I mean,
I
here
don't know whether it was Jen that was called, but I mean.
Oh, sorry. It was just because I wanted to branch out beyond constitutional.
That's okay.
Yeah, I mean, I have something I could add maybe to provide a counterpoint to Richard's, some of Richard's statements about AI tools and their use. So here I'm talking about generative AI tools and their use in summarizing different documents, or even when it comes to translation. So here, I mean, the type of documents in the context really matters, and of course the generative AI tool as well. So for example, in the immigration letter that I introduced earlier, where there's a suggestion that some sort of generative AI tool, we're not told which one, has been used to process an application, and where I suspect some of what the use might have included would be tasks that involve summarizing and even perhaps translating documents that are, vital sources of evidence for somebody's application for a particular visa or status. There, I would have some serious concerns about the use of AI tools for a variety of reasons, not just because generative AI tools, although they're commonly used to summarize documents, do not always do so very well. And the errors or, if you want to call them hallucinations that are produced vary along lines that are connected to language, complexity of the data, and also that intersect with the type of training data that these tools have been trained on in the first place. So in those contexts, although governments have been turning to these tools because they assume that they can do the work faster and then speed up application processing times, I have real concerns about the quality of the information that's produced on the other end. And then, of course, the degree to which the workplace in which these tools are being used has changed such that the administrative officials have less and less time to double check the accuracy. So I think that oftentimes we might assume that these types of tools or systems can do the work better, faster, they produce relatively reliable results. And I think that that as a blanket statement is not very helpful and actually can lead to other types of decisions, including government agencies reducing the amount of time associated with reviewing applications and speeding up decision production times in ways that look like an assembly line, where you have kind of decision production speeding up, but the quality of the decision becoming more and more a point of concern and of question for administrative lawyers. So I think that there's really important and challenging, I think, issues facing a lot of administrative lawyers, a lot of people who are applying for things these days, where they might receive a fast rejection, but to what degree is that at all satisfying? And the rejection might come with a letter that it uses language that seems a bit more intelligible or softer around the edges, but is that, to what degree is that also satisfactory? And this is where you have administrative law, I think, connecting with concerns related to constitutional law when it comes to faith in our institutions, the sense that people are being treated fairly, upholding of the rule of law, and so on and so forth. And so I think that there are a lot of really kind of complicated layers that are introduced when Gen AI tools are used in these settings. And I think that there's a real need for specificity and kind of criticality on the part of the folks who are reviewing the use of these tools to ensure that they're not just speeding up rejections with a soft kind of outer edge without much appreciation for perhaps the limits that in terms of functionality, but also maybe in terms of kind of constitutional or rule of law guardrails that we might want to place around the use of these tools for the reasons that I've expressed. So I don't know, Giovanni, if you wanted to add to that.
Yeah, I mean, there would be so much to add here, that's interesting, because this opens the question once again of accountability. That's why I was stressing the point. Because this opens the question about remedies, or redress, what you can get, from a decision by a public administration or by government, actually, that is taken totally or, by a machine, just to simplify. This has been a conversation, particularly also in the US, in Europe, and also somewhere else in the world about, the decision makings and explanation. But, still the point is about which types of tools in administrative law and broadly speaking, public law, do we have to face a lack of accountability? Of course, the public administration will be accountable, but accountable for what? Because it will be difficult even for them to explain. And especially the more even public administration, but also this also works for courts, the more AI is entering the ways of private and public enforcement, let's say, just to simplify, the more it will be complicated to justify, or at least to say, the machine says so, what I can say, more than that, because there is a degree, we need to accept that there is a degree after which, it's so costly to explain that it doesn't make any sense. But still there is a question, for rights protection and you name it, once again, so we need probably to think about how we can understand, how also the access to remedies, and that also is actually what is important, especially when we talk about constitutional safeguards, for people, what they can do when there is a rights violation from a public administration that they decide to deny, or, but this also works for some private actors, that they play, that are in a quasi-public role, there are many, that they play like an infrastructural function almost, and of course they can say no, and you have pretty much no remedies lacking any regulation, but also regulation is not the solution, because at the point the regulation is also calls for public enforcement as well, not only private enforcement sometimes. And this, of course, you enter once again in the circle of having public administration enforcing regulation through AI. So you cannot escape from there, so I think that there is a call and a lack of accountability at the basis that the discussion should go there, how we can develop actually ways to understand, who can provide, not only a motivation, but can be accountable for a decision, because we will get to the point where it will be very hard, even for a court, for a public administration, for a company, to explain what's going on. Because for now we are trying through impact assessment, through risk regulation, to push a little bit, there would be someone explaining that, to delegate this type of explanation. But at the end, sooner rather than later, the more these systems and application will expand, it will be across society, especially spread across public administration. It's also a question of imbalance of resources, as you know. It will be, sooner rather than later, we'll have to talk about that. I mean, this is my view. That's actually where is the problem also with AI. One of the big challenge there, it's also about providing remedies, and how to address these remedies.
Yeah, that's great. Discussion around kind of bridging I think the gap, or the discussion between kind of the disadvantages from a practical side, and also like the broader constitutional implications. I guess, does anybody else want to come in terms of kind of the, I guess, broader kind of constitutional implications in terms of things like the rule of law or other constitutional values or constitutional rights? Does anybody have any particular concerns that they want to kind of interject? Feel free to raise your hand, or no pressure, just if people wanted to come in on that kind of issue.
I do, if that's all right. I know I feel like I've been saying a lot here, but one thing that I would say that's important, that I've noticed in my own research, is that, so sometimes we focus on the technologies and how the technologies are changing government from within and so on and so forth. One thing I've noticed is that there's a lot of technological concepts that, or you could think of it as like tech thinking, that is slipping into the way that public lawyers describe the things that they do, or even what they expect of governments in the first place, that I think is fascinating as a socio-legal researcher, but also something that's happening without much concern or thought about whether the concepts are appropriate, or whether they, whether something is lost or something changes when we alter the way that we think about certain commitments in public law. So an example of that would be, for instance, the shift from expecting decisions to be justified by decision makers to instead expecting that they just be explainable. So, explainable AI is a whole field of study and scholarship within computer science. There's been a lot of technical moves to ensure that AI systems might be more or less explainable, and different, developments along those lines. But I've also seen public lawyers just jump into explainability as the thing that's required in public law, when that's not necessarily the case. Like, I think it's useful for public lawyers to pause a little bit and maybe, reconsider why it is that they're starting to use different terms and what might be lost along the way. Because in common law systems, the requirement for justification, and even the whole, culture of justification literature, it requires something different than that, the pathway to a decision be explained so that you know how the decision was produced, but that there also be a statement that justifies why the outcome is appropriate according to the applicable laws, and so on and so forth. And so I've seen this happen in many ways. Another shift that I've seen is the falling away in Canada of the value of substantive equality, which is a fundamental value within our charter, that lawyers, like constitutional lawyers, are not even talking about this in relationship to the use of AI by government agencies. It's just slipped away, and even activists and so on have stopped using that language, and they've been using more of the US type of language of, that focuses a bit more on equal application of the law, and so on and so forth. And these are, I think, are fascinating, but also, signs that there are many other ways in which AI is changing how we imagine constitutional and public law values, not just how we as like members of the public imagine these things, but even how we as legal scholars imagine them, or how public lawyers imagine these things. So I think that that's an important point of reflection for all of us, and also something to be attentive to in the work that we do, because I do think that there are bigger shifts afoot, and the degree to which we're paying attention to those and making that those shifts are happening because there's something that we've thought about and chosen, or whether they're just kind of a casual slippage into a different type of constitutionality, is worth, I think, keeping in mind and even responding to.
David, if I may, just very quickly, you know, like, because this is very much relevant also for what Mila and Richard said, you know, like, because at the end, you know, like, the challenge is that, you know, like, most of the, you know, like, since there is also like an imbalance in the research that is developed about, you know, constitution, and this is also, you know, reflected, probably will be reflected in the way in which AI interprets certain constitutional concepts when you ask questions, you know, because it's also about how is this trained, where it got most of the content, in terms of constitutional concepts that are more attached or belonging to a certain constitutional culture will tend to migrate. It's very interesting for comparing constitutional law to see how this concept will migrate from one side to the other one, you know, like, and this opens, of course, you know, like many questions about the use of AI, is about language for large language models. This is like a huge question. It's also to connect with Mila, Richard. I think this was a very important question that we have.
Can I quickly jump into this? Without not really going into the bigger question, but to the extent there's a concern about, I mean, AI being trained in particular languages and particular concepts. So we try to explore that, whether it was better at getting the like bigger, wealthier countries, right? And whether it was better at English-speaking countries. And we found no evidence that this was the case. So it was did well across the board on these kind of tasks that were easy tasks. And for the more complicated tasks, it fumbled across the board in a systematic manner. But we looked for this kind of bias and we did not find it. I mean, that doesn't necessarily mitigate the concerns in like when you think about like actual applications in administrative law. I mean, there you just want to be 100% sure that this doesn't exist, but we did not find this in research in any case.
Okay, great. And I guess for one final question, and I'll bring it back to Richard, if that's okay. I guess one thing that I think kind of, you know, exists is that there's certain kind of, shall we say, misconceptions that are commonly held about AI and perhaps its relationship to constitutional law. So as kind of a final question, Richard, in your research, or, you know, in terms of constitution making, constitution drafting, have you found that there are particular kind of, is there one particular misconception that you think needs to be kind of resolved or needs to be kind of clarified?
Yeah, thank you, David. I'll say something about that, but first let me answer your question a bit more broadly. And it's something, it occurred to me yesterday. I had office hours with my students, and a student came in and we're talking about an upcoming evaluation, a midterm examination. And AI came up in the course of our conversation, the use of AI to answer a question. And she said to me something like, oh, well, I know I'm not supposed to use AI, not just in writing the exam, but just in general for school. And my response to her, I mean, at first I was a bit surprised. And then I walked through the hallways here at my law school and I asked some colleagues, well, what do they do when they build their syllabi? Do they say no AI use, or do they encourage it? Do they incorporate it somehow when they're teaching and they're learning? And it's kind of split here at the University of Texas at Austin. And I think the misconception that I want to bring to the table here is that it's best for the students to have them leave AI off of the table in the work that they do. I understand asking students to complete evaluative assessments without the use of AI, fine. But in the way they learn, I think that's doing them and this university a disservice. I think the future of the world belongs to those who can harness the extraordinary capacity of AI for themselves and for their society and for the people that they care about. And so that's really an invitation to us all as teachers to really be thoughtful about what we tell our students about AI. This student yesterday, it was almost like it was kryptonite, toxic. I can't touch AI. And I'm hoping that she comes to realize soon that it should be the opposite. But as relates to constitution making, I think the most common misconception that I've encountered most notably in relation to a paper that I just co-wrote with a colleague, Kevin Frazier, titled "Should AI Write Your Constitution?" ? Our answer is no. AI should not write it, but it should be useful to you in some parts of the constitution making process. And the more people learn about AI's capacities, I think the more AI will be demystified. And the more people use it in their everyday lives, the more they'll become comfortable with using it for almost everything. There always will have to be some human oversight. Constitution making, in my view, and in the work that I've done as an advisor, must necessarily remain human-led, has to be. But some parts of it, some important parts of the constitution making process, they're going to be a blend, a fusion of machines and humans, but humans have to remain on top with ultimate and final oversight. So just to close, the misconception is that in constitution making, the use of AI is that it's a problem. It's something to be avoided. No, I think it's quite the opposite. It can be used responsibly, and we just have to figure out what those answers are, and those answers will differ from one jurisdiction to the next. Even within jurisdictions, they'll differ. And so that's what I would encourage us to think about is not to keep AI away. It's here. It's here to stay. I've given an example of how it was used in the making of a constitution already. We just have to be responsible in how we use it.
Great. No, I think that's an excellent way to close. And recognizing that we're low on time, I'm going to kind of bring the discussion to a close. Unfortunately, we couldn't get to audience questions, partly because of the technical issues and partly because the discussion went long, but that's great because it was, I think, a really great discussion. So Mara and I would just like to, of course, thank everyone. So, of course, we'd like to start by thanking our wonderful panel of speakers for, I'm sure what everybody can agree is a really insightful and really, I think, intriguing discussion in light of where we are in the world right now. We'd also like to thank our audience for joining us today. As always, a recording of the event will be uploaded relatively shortly to the Center for Constitutions in Context YouTube channel, so you can keep a lookout for that if you want to refer back to it. And also, as always, if you want more information about our center's activities, including upcoming events, please do take a look at our website or our social media pages. And if you'd like, subscribe to our various pages, including our email list. So yeah, thanks again to everyone for joining us, including our speakers. And depending on where you're joining us from in the world, enjoy the rest of your day or evening.
But David, hang on, David. No one has thanked you and you and Mara. Thank you so much. All the events you do are really remarkable. So thanks, and we hope you keep doing them because they're so valuable to us all. So thank you.
Thank you.
Thank you so much.
Bye, everyone.
Bye, everyone. It was wonderful. Thank you.